Question 1. A registered representative plans to send an email to 10 retail clients and 5 institutional clients discussing a new investment product. How would this communication be classified and what approval is typically required? A. It is classified as retail communication and requires principal approval. B. It is classified as institutional communication and does not require principal approval. C. It is classified as correspondence and does not require principal approval. D. It is classified as correspondence, but because it includes retail clients, it requires principal approval. Answer: A. It is classified as retail communication and requires principal approval. Any communication that is distributed or made available to more than 25 retail investors within any 30 calendar day period is classified as retail communication. Since this email is going to 10 retail clients, it falls under the definition of retail communication, which mandates principal approval before it is first used. Even if the majority of recipients were institutional, the presence of more than 25 retail investors determines the classification and the need for review. Remember, the rules are stricter when retail investors are involved to ensure they receive balanced and fair information. Question 2. Under FINRA rules, what is the maximum value of a gift a registered representative may give to a client annually? A. No limit, as long as it is for business purposes. B. $100 per person per year. C. $250 per person per year. D. $1,000 per person per year. Answer: B. $100 per person per year. FINRA rules on gifts and gratuities state that a registered representative may not give anything of value in excess of $100 per person, per year to any person where such payment relates to the business of the recipient's employer. This rule is in place to prevent the inappropriate influence of business decisions through excessive gifts. However, business entertainment, such as an occasional dinner or sporting event, is permitted if the representative attends with the client. Always be mindful of the $100 limit for direct gifts. Question 3. Which of the following is considered correspondence under FINRA rules? A. A letter sent to 20 retail clients regarding a new mutual fund. B. An email sent to 60 institutional clients promoting a new bond offering. C. An instant message sent to 10 existing retail clients about an investment strategy. D. A website page accessible to the general public describing the firm's services. Answer: C. An instant message sent to 10 existing retail clients about an investment strategy. Correspondence is defined as any written, including electronic, communication that is distributed or made available to 25 or fewer retail investors within any 30 calendar day period. An instant message to 10 existing retail clients fits this definition perfectly because it reaches fewer than 26 retail investors. In contrast, a letter to 20 retail clients or a website would be retail communication, and an email to 60 institutional clients would be institutional communication, as these reach more than 25 retail investors, or are intended for the general public/institutional only. Keep the 25 investor threshold in mind for correspondence. Question 4. What is the required retention period for retail communications under FINRA rules? A. 1 year. B. 3 years. C. 5 years. D. 6 years. Answer: C. 5 years. Under FINRA rules, firms are required to retain all retail communications, along with evidence of their principal approval and any other related records, for a period of 5 years from the date of last use. This retention period ensures that FINRA has sufficient time to review and audit a firm's past communications for compliance purposes. Remember, the first 2 years of this 5-year period require the records to be kept in an easily accessible location. Question 5. A registered representative wishes to engage in an outside business activity, OBA, that is unrelated to the securities industry. What action is required under FINRA rules? A. No action is required as long as it is unrelated to the securities industry. B. The representative must obtain written permission from FINRA before engaging in the OBA. C. The representative must provide prior written notice to their employing member firm. D. The representative must disclose the OBA on their Form U4 during the annual update. Answer: C. The representative must provide prior written notice to their employing member firm. FINRA rules require that a registered person must provide prior written notice to their employing member firm if they wish to engage in any outside business activity, whether compensated or not, and whether or not it's related to the securities industry. The purpose of this rule is to allow the firm to determine if the OBA presents any potential conflicts of interest, appears to be an undisclosed private securities transaction, or could compromise the representative's primary duties. Always inform your firm in writing before starting any outside work. Question 6. A registered representative creates a personal blog where they occasionally post their opinions on market trends and specific investment products, without any endorsement from their firm. Which of the following statements is true regarding this activity? A. Since it's a personal blog, it is not subject to FINRA rules. B. This content is considered retail communication and is subject to FINRA's supervision and record-keeping rules. C. It is considered correspondence and requires only post-use review by a principal. D. The firm must prohibit the representative from maintaining such a blog. Answer: B. This content is considered retail communication and is subject to FINRA's supervision and record-keeping rules. Even if a registered representative uses a personal device or account, any communication that relates to the firm's business or to investment products and reaches more than 25 retail investors is generally considered retail communication. Content on a public blog, like this, is readily available to a broad audience and is therefore subject to FINRA's rules on communications with the public, including principal approval and record-keeping requirements. Firms must supervise and retain records of all such communications, regardless of the platform used. Question 7. Under what circumstances may a registered representative borrow money from a customer? A. Under no circumstances is borrowing from a customer permitted. B. Only if the customer is a bank or financial institution. C. If the customer is an immediate family member and the firm has written procedures allowing it. D. Only with prior written approval from the firm, regardless of the relationship. Answer: C. If the customer is an immediate family member and the firm has written procedures allowing it. FINRA rules generally prohibit registered representatives from borrowing money from or lending money to a customer. However, there are limited exceptions. A representative may borrow from or lend to a customer who is an immediate family member, example parent, grandparent, spouse, sibling, child, grandchild, without firm notice or approval, provided the firm has written procedures allowing such activity. Other exceptions include if the customer is a bank, or if the loan is based on a personal relationship, not a business one, and firm approval is obtained. Always ensure any borrowing or lending falls squarely within permitted exceptions. Question 8. What is the primary purpose of a business continuity plan, BCP, for a broker-dealer? A. To ensure all employees can work remotely during a natural disaster. B. To minimize the impact of significant business disruptions on the firm's operations and customers. C. To provide a framework for filing customer complaints with FINRA. D. To outline the firm's marketing and advertising strategies for the next fiscal year. Answer: B. To minimize the impact of significant business disruptions on the firm's operations and customers. The primary purpose of a business continuity plan, BCP, is to outline procedures for how a broker-dealer will respond to significant business disruptions, such as natural disasters, power outages, or cyber attacks, to ensure the firm can continue to operate and meet its obligations to customers. Firms must establish, maintain, and annually review their BCPs to ensure they are current and effective. A strong BCP is critical for protecting customer assets and maintaining market integrity during unforeseen events. Question 9. Which of the following is considered a complaint under FINRA rules? A. A verbal expression of dissatisfaction from a customer regarding a transaction. B. A written statement of grievance from a customer regarding an investment or service. C. An inquiry from a customer about their account balance. D. A suggestion from a customer to improve the firm's website. Answer: B. A written statement of grievance from a customer regarding an investment or service. Under FINRA rules, a complaint is defined specifically as any written statement of a customer, or any person acting on behalf of a customer, alleging a grievance involving the activities of the member or any associated person in connection with the solicitation or execution of any transaction or the disposition of funds or securities of that customer. While verbal complaints are important for customer service, only written complaints trigger the specific regulatory reporting and record-keeping requirements. Firms must maintain a separate file for each written complaint and report them to FINRA quarterly. Question 10. A firm's website includes a page featuring a testimonial from a satisfied customer. What is a key requirement for using such a testimonial in retail communication? A. The testimonial must be from an institutional client only. B. The firm must state whether the testimonial was paid for, if applicable, and if it is not representative of all client experiences. C. The firm must obtain FINRA approval before posting the testimonial. D. Testimonials are prohibited in all retail communications. Answer: B. The firm must state whether the testimonial was paid for, if applicable, and if it is not representative of all client experiences. FINRA rules allow the use of testimonials in retail communication, but they come with strict disclosure requirements to ensure they are not misleading. If the testimonial concerns a technical aspect of investing or investment company services, the person making the testimonial must be qualified to make such a statement. Crucially, if the testimonial is paid for, that fact must be disclosed. Additionally, a statement must be included that the testimonial may not be representative of the experience of other clients and is not a guarantee of future performance or success. These disclosures help ensure transparency for investors. Question 11. Which of the following statements about guaranteed returns on investments is true under FINRA rules? A. Guarantees are permitted if they apply to a specific type of investment, such as government bonds. B. Guarantees on the return of principal or interest are generally prohibited in communications with the public. C. Guarantees are allowed as long as they are clearly disclosed as being from a third party, not the broker-dealer. D. Guarantees are permissible only if the investment is insured by the Securities Investor Protection Corporation, SIPC. Answer: B. Guarantees on the return of principal or interest are generally prohibited in communications with the public. FINRA rules prohibit member firms and registered representatives from making any statement that guarantees future performance or implies that an investment will not lose money. This includes guarantees on the return of principal or interest, as all investments carry some level of risk. The only exception to this prohibition is if a guarantee is made by a third party, like an insurance company, and the communication clearly states who is making the guarantee and that the firm is not the guarantor. Securities are inherently risky, and firms cannot promise specific returns. Question 12. A broker-dealer must submit its Business Continuity Plan, BCP, to FINRA. A. Annually for approval. B. Every 3 years. C. Only upon request. D. Never. It must be maintained at the firm but not submitted. Answer: D. Never. It must be maintained at the firm but not submitted. While a broker-dealer is required to establish, maintain, and annually review its Business Continuity Plan, BCP, to ensure it is up to date and effective, they are not required to submit the BCP to FINRA for approval or review on a regular basis. The BCP must be made available to FINRA upon request. This approach allows firms flexibility in tailoring their plans while still ensuring regulatory oversight if needed. Question 13. A registered representative updates their personal social media profile, example LinkedIn, to reflect their new job title at a broker-dealer. This change on a static profile page is considered A. Retail communication, requiring prior principal approval. B. Correspondence, requiring post-use review. C. Institutional communication, requiring no review. D. Public appearance, which does not require review. Answer: A. Retail communication, requiring prior principal approval. Even though a social media profile is often considered static content, meaning it isn't constantly updated, if it communicates information about the firm's business, products, or services to more than 25 retail investors, it falls under the definition of retail communication. Changes to such a profile, especially reflecting employment with a broker-dealer, must be treated like any other retail communication, meaning it requires prior principal approval before being publicly posted. This ensures accuracy and compliance with advertising rules. Question 14. What is the primary purpose of FINRA's Code of Procedure, COP? A. To resolve monetary disputes between member firms and customers. B. To outline the rules for disciplinary actions against member firms and associated persons. C. To establish guidelines for underwriting new securities. D. To define the requirements for registering as a broker-dealer. Answer: B. To outline the rules for disciplinary actions against member firms and associated persons. FINRA's Code of Procedure, COP, sets forth the formal process for handling disciplinary actions against member firms and associated persons who violate FINRA rules or federal securities laws. It outlines the steps from investigation and complaint filing to hearings, appeals, and the imposition of sanctions. In essence, the COP is FINRA's rulebook for enforcement and discipline. Question 15. All of the following are typically included in a broker-dealer's business continuity plan, BCP, except A. Data backup and recovery strategies. B. Alternate communications between the firm and customers. C. Detailed client investment portfolios. D. Employee contact information for emergency purposes. Answer: C. Detailed client investment portfolios. A broker-dealer's business continuity plan, BCP, is designed to ensure the firm's continued operation and ability to serve customers during significant business disruptions. It includes elements like data backup, alternative communication methods, and emergency contact lists for employees and critical vendors. However, detailed client investment portfolios are typically stored in the firm's secure operational systems, not as a core component of the BCP itself, although access to these systems would be a critical part of recovery. The BCP focuses on operational resilience, not specific client account details. Question 16. If a registered representative receives a written customer complaint, what is the first step the representative should generally take? A. Attempt to resolve the issue directly with the customer. B. Forward the complaint to their immediate supervisor or designated principal. C. File the complaint with FINRA immediately. D. Advise the customer to seek legal counsel. Answer: B. Forward the complaint to their immediate supervisor or designated principal. Upon receiving any written customer complaint, the very first step a registered representative should take is to promptly forward the complaint to their immediate supervisor or a designated principal. Firms are required to have procedures in place for handling complaints, which include review by a principal, investigation, and proper record-keeping. Attempting to resolve it personally or filing with FINRA are not the initial steps. Always remember that complaints trigger a formal process requiring firm management oversight. Question 17. Which of the following describes institutional communication under FINRA rules? A. Any written communication sent to a single retail investor. B. Any written communication sent to more than 25 retail investors within 30 days. C. Any written communication distributed or made available only to institutional investors. D. Oral communication delivered to a large group of high-net-worth individuals. Answer: C. any written communication distributed or made available only to institutional investors. Institutional communication is defined as any written communication that is distributed or made available only to institutional investors. Institutional investors include entities such as banks, savings and loan associations, insurance companies, registered investment companies, and registered investment advisors, among others. Because these investors are generally more sophisticated, institutional communications do not require principal pre-approval but are subject to review and supervision by the firm. The key is that it's only for institutions. Question 18. A firm must maintain records of all communications, including emails and instant messages, for a period of at least A. 1 year. B. 3 years. C. 5 years. D. 6 years. Answer: B. 3 years. FINRA rules require firms to maintain records of all communications, whether written or electronic, like emails and instant messages, for a period of at least 3 years. This record retention period is crucial for regulatory oversight and to ensure that a firm can demonstrate compliance with communication rules. For the first 2 years of this 3-year period, these records must be kept in an easily accessible location. Question 19. If a registered representative wishes to participate in a private securities transaction, selling away, what is required? A. No notification is required if the representative does not receive compensation. B. Notification to and approval from FINRA is required. C. Prior written notice to the employing member firm, and if compensation is received, the firm must approve and supervise the transaction. D. Only verbal notification to the firm is sufficient. Answer: C. Prior written notice to the employing member firm, and if compensation is received, the firm must approve and supervise the transaction. Private securities transactions, also known as selling away, occur when an associated person sells securities outside the normal course of their employment with their member firm. A registered representative must provide prior written notice to their employing member firm before engaging in any such transaction. If the representative will receive compensation for the transaction, the firm must also approve the transaction in writing and record it on its books, supervising the transaction as if it were its own business. This rule aims to prevent undisclosed conflicts of interest and unauthorized sales activities. Question 20. Under the Code of Arbitration, COA, which of the following disputes is typically resolved through arbitration? A. Disputes between FINRA and a member firm regarding rule violations. B. Disputes between a member firm and its customer regarding monetary claims. C. Disputes between a registered representative and FINRA over licensing issues. D. Disputes between two member firms regarding a regulatory audit. Answer: B. Disputes between a member firm and its customer regarding monetary claims. FINRA's Code of Arbitration, COA, is the mechanism for resolving monetary disputes between member firms, associated persons, and customers. Most new account forms include a pre-dispute arbitration agreement, which means customers agree to resolve disputes through arbitration rather than litigation. This process is generally faster and less expensive than traditional court proceedings. Disciplinary actions, A, and licensing issues, C, fall under the Code of Procedure. Question 21. Which of the following statements is true regarding a firm's name under FINRA rules? A. A firm's name can imply that it is a public entity even if it is not. B. A firm's name must be approved by FINRA before use. C. A firm cannot use a name that implies it is a bank or savings institution unless it is one. D. A firm may use any name as long as it is unique. Answer: C. A firm cannot use a name that implies it is a bank or savings institution unless it is one. FINRA rules prohibit member firms from using a name that is misleading or would imply that the firm is a bank, trust company, or other similar institution unless it is, in fact, registered and regulated as such. This rule prevents investor confusion and ensures that firms' names accurately reflect their business and regulatory status. Firms must ensure their names are not deceptive or confusing to the public. Question 22. When an investor opens a new account with a broker-dealer, they are typically provided with a statement that includes a pre-dispute arbitration agreement. What does this agreement signify? A. The customer agrees to resolve all future disputes through litigation in court. B. The customer waives their right to file a complaint with FINRA. C. The customer agrees to settle any future disputes with the firm through binding arbitration. D. The customer acknowledges that the firm is not liable for any investment losses. Answer: C. The customer agrees to settle any future disputes with the firm through binding arbitration. A pre-dispute arbitration agreement, commonly found in new account forms, means that the customer agrees to resolve any future disputes with the broker-dealer or its associated persons through FINRA's Code of Arbitration, rather than through a lawsuit in the courts. This agreement is binding, meaning both parties are bound by the arbitrator's decision. While arbitration has benefits like being generally quicker and less expensive, it also means giving up the right to a jury trial. Question 23. FINRA Rule 2273 requires member firms to provide educational communication to customers who are considering A. Opening a new margin account. B. Rolling over their retirement plan assets from a 401k to an IRA. C. Investing in a complex options strategy. D. Engaging in a private securities transaction. Answer: B. Rolling over their retirement plan assets from a 401k to an IRA. FINRA Rule 2273 specifically requires member firms to provide educational communication to customers who are considering rolling over retirement plan assets from a 401k or similar plan to an IRA. This communication must highlight the various factors to consider, such as fees and expenses, investment options, and services, to help customers make an informed decision. The rule aims to protect investors by ensuring they understand the potential implications of such a significant financial decision. Question 24. A registered representative discovers a typographical error in an email that was classified as correspondence and sent to 15 clients. What is the appropriate next step for the firm regarding this error? A. No action is needed since it was sent to fewer than 25 clients. B. The firm must immediately recall the email and send a corrected version to all recipients. C. The firm should note the error in its records and, if the error is material, send a corrected communication. D. The registered representative must be immediately disciplined for the error. Answer: C. The firm should note the error in its records and, if the error is material, send a corrected communication. Even for correspondence, firms must ensure that communications are fair, balanced, and not misleading. While correspondence does not require prior principal approval, it is subject to review and retention. If an error, especially a material one, is discovered, the firm should make a record of it and take appropriate action to correct the information, which would typically involve sending a corrected communication. This ensures compliance and maintains trust with clients. Question 25. An associated person must update their Form U-4 within how many days of a material change, such as a change of address or a disciplinary action? A. 10 days. B. 30 days. C. 60 days. D. 90 days. Answer: B. 30 days. FINRA rules require that any material changes to information reported on an associated person's Form U-4, Uniform Application for Securities Industry Registration or Transfer, must be updated promptly, specifically within 30 days. Examples of material changes include changes in residential address, educational background, disciplinary actions, or new outside business activities. Maintaining accurate and up-to-date U-4 information is crucial for regulatory oversight of registered individuals.